Good morning and welcome, and I appreciate you guys being understanding with this week's lecture and sort of letting me have the space that I need to manage my own health. So, as promised, this is the lecture to discuss the material that we would have covered on Wednesday. It is intended to cover in more detail the subjects of contributory negligence and Valenti non-fit injuria, right? Assumption of the risk. As per usual, these pre-recorded lectures are going to move a little faster. They're not going to occupy the entire time period of a class, and you are, of course, welcome to communicate with me via email to ask any questions that may arise after you've reviewed the lecture and your notes. An administrative note, in Monday's lecture, we will discuss briefly how we're going to handle the midterm in terms of timing, and then I will communicate with you guys via email to explain sort of what's going to happen. Okay, so contributory negligence is, as I said last week, basically the notion that where the plaintiff is also at fault for their own injury, that it's not fair to hold the defendant completely responsible. And the original common law doctrine of contributory negligence is that if the plaintiff is 1% at fault, any fault can be attributed to the plaintiff loses. Okay? And there are some jurisdictions that still adhere to this doctrine. The place where I went to law school in Alabama still adheres to the common law contributory negligence doctrine. However, most common law jurisdictions have either through judicial innovation or by statute have modified the original common law contributory negligence doctrine. What is now used in the Caribbean is almost always referred to as contributory negligence. In places like the United States, where the common law doctrine still holds, the Caribbean doctrine is called comparative negligence. Okay, so if you ever hear me talk about comparative negligence, know that I am talking about the Caribbean contributory negligence doctrine. And what that doctrine says is that instead of simply wiping away a plaintiff's injuries in the event that they are partially at fault, that the recovery is reduced by the allocation of fault. And so if a plaintiff is adjudged to be 20% at fault in the accident, and that's a fairly common number in the Caribbean, then they recover 80% of their assessed damages. So just to put hard numbers on this to make this sort of concrete for you guys, if a plaintiff is assessed as having $100,000 in damages and they are found to be 20% at fault, their judgment against the defendant will be for $80,000. So the damages that they were assessed reduced by the percentage of fault that is held to the plaintiff. Okay? There is a third approach to this doctrine, which is used in some jurisdictions. It's called a modified comparative negligence, which says that we're going to use the Caribbean approach to contributory negligence up to the point where the plaintiff is has the majority of fault, so 50% plus something, right? And you guys will recall that I talked about 50% plus something when we talked about the balance of the probabilities. So if the plaintiff is 50% plus something at fault, then we have common law contributory negligence and they recover nothing. So even if the defendant is negligent, even if the defendant loses on causation, even if they lose on remoteness in these modified jurisdictions, if they can show that the plaintiff was more negligent than they were, the plaintiff gets nothing. Okay? In most Caribbean jurisdictions, even if the plaintiff is more than 50% at fault, there's just an assessment, an allocation of damages that is appropriate based on the percentage of fault. So again, right, $100,000 in damages if the plaintiff is 51% at fault, their judgment is for $49,000, which is the percentage of the damage that is attributable to the defendant. Okay? Now, if you're sitting here and you're thinking, you know, I went into law because I was told there would be no math, I understand, and this is about as difficult as it's going to get in this class, is allocation of fault and calculating allocation of damages on that basis. One thing to keep in mind is that contributory negligence is not based on a duty that the plaintiff owes to the defendant, right? It's not built on the notion, oh, you didn't keep a proper lookout to protect me, the defendant. It's you didn't keep a proper lookout to defend yourself. Okay, so this is a duty of care that is owed to yourself. Okay, and this is why contributory negligence is a defense to liability and not a counterclaim. Okay, keep that in mind, right? Contributory negligence is not a counterclaim, so the plaintiff has no relationship with the defendant. There's no tort that the plaintiff has committed. It is that the plaintiff failed to take care of themselves. Okay? And in order to make out a claim for contributory negligence, in order for the defense to be successful, the defendant must show that the plaintiff's injuries would have been lessened had they not engaged in their own negligence. And I think there's a really useful case in the materials that shows how that burden can be used by a defendant to overcome a tort claim, and that case is Thurston versus Davis, and unfortunately my notes don't have anything on it, so let me look it up very quickly so that I can give you just a nutshell description. 381. So this is on page 381 of the Codalini book. And it's a case about seatbelts. So this is from 1992, you know, when seatbelts were just sort of beginning to become a thing in the Caribbean, and the injuries, it was undisputed that the plaintiff was not wearing their seatbelt. But the court held that that didn't matter because their injuries were such that the seatbelt would not have fixed it. Okay? A couple of other things that are important points in contributory negligence analyses. One is that if someone is injured in the workplace, right, so they're injured while they're working in the course of their employment, the duty of care that they owe to themselves in order to avoid contributory negligence is lessened than in sort of the ordinary course of events, because sometimes the risks that you take at work are at your employer's behest, right? The employer tells you to do this risky thing, or it's under the employer's control. And so it's very likely that the employer is going to be held to be responsible for any risky behavior that the employee undertakes. In order to avoid that conclusion, employers need to take steps to prevent the contributory negligence. And these can be very simple, right? Posting safety warnings, issuing workplace regulations that say you are required to, take these steps to protect yourself from dangerous situations in work. But these things have to be in place in order for the worker's contributory negligence to actually come into play. And there's a case, a really useful case, that talks about this called Smith versus Chesterfield and District Cooperative Society Limited. The next thing that I want to talk about in the question of contributory negligence is the lessened duty of care that children owe themselves. Okay, so you guys may recall, right, at the very beginning of the semester, we talked about the duty of care that child defendants owe. And we said there's not really like a special standard for the duty of care that a child tortfeasor owes, in that they're expected to behave with the same due regard for the safety of others as adults. And I think some of that is because when it comes to the safety of others, children are expected to be under the control of adults. So if a child can't adequately recognize the risk that their behavior is creating, it behooves adults who control that child to make sure that they behave in a manner that is safe for others. But in contributory negligence, children are held to a lessened duty of care for themselves. The contributory negligence standard for a child plaintiff is the standard that is appropriate to their age and understanding. And there's even some case law that you can find, and the textbook cites to it. There's some case law that you can find that says that very young children, and the court, of course, does not say what very young means, but probably certainly less than 10. Very young children cannot be held to be contributorily negligent because they do not have an understanding of risks to themselves. Okay? And even older children, teenagers, have to be held to a standard that is appropriate to their age and their understanding. And I want to point you guys to the case of Smith versus Rodney, where the court explicitly says, if the plaintiff had been an adult, there is no doubt that the contributory negligence defense would have been successful, and there would have been a fairly significant reduction in damages. But because they're a child, we do not hold them to the same standard. Okay? So, one of the most common types of cases that involve assertions of contributory negligence are road accidents. Okay? And the reason for this, right, is because there are so many things that play a part in the determination of a road accident, right? So many different pieces of the puzzle that it is in every defendant's interest to plead contributory negligence and see what they can find out from the plaintiff, right? So I would encourage you to spend a little bit of time thinking about the policy considerations that underlie the litigant choice to plead contributory negligence in road accident cases in particular, and to ask whether there are mechanisms that might undermine that policy choice, whether there are things that we can do in the legal system that would make that defense less attractive. And this isn't to say that we should do those things. This is just to ask, okay, let's assume that we want to, as a thought exercise, what might that look like? Okay? So that's contributory negligence. Okay? The other thing that I want to talk about is what in the Commonwealth is referred to as volenti non fit injuria. In the United States and in some Commonwealth cases, it's referred to as assumption of the risk. Like I said last week, the idea behind this is that if I tell you that I want you to hit me as hard as you can, I don't get to turn around and sue you when you do it. Okay? But courts draw a distinction between being aware of a risk and consenting to the risk. So, you guys are all familiar with the signs sort of everywhere that there's parking in, on this island. Signs saying, the property owner accepts no liability for, theft or damage, those sorts of things. And so my question to you is that a meaningful expression of consent? Does just posting that sign create consent to any risk, or does it simply create knowledge of the risk? And this distinction also becomes important in workplace injury cases, because just like with contributory negligence, the worker accepting the fact that there are risky work conditions does not constitute consent to the risk. Okay? The courts in the Commonwealth, and this is one thing that Commonwealth courts do much better than American courts, and I want to be clear about that. Commonwealth courts recognize the power dynamics of the workplace. And they recognize that the decision, accept this risk or don't work here, this is very frequently not a real choice. That don't work here is very frequently not a viable option. And so the courts recognize that there's not really an acceptance of the risk here. Okay, and there's a number of cases in the text that sort of point you to this in more detail. I would encourage you to read in particular Forbes versus Burnhouse Limited. With that, you can see that this is very brief, right? We're done. This is everything that you need to know about contributory negligence and assumption of the risk. So, once again, on Monday, we will discuss the exam in a little bit more detail. This week, you should expect to spend your time, your course time, in revision. Okay? And that's really all there is to it. So we will spend that time in revision. I will be available to answer questions, and we'll take it from there. Okay? So I will see you guys on Monday. Take care, and bye.